Well, hello, everybody, and welcome to Barclay Damon's Labor and Employment Podcast. I am Rosemary Enright, and Mike, this time you introduce yourself.
I am not Rosemary Enright. I am her partner, Mike Sciotti. I am stationed in the Syracuse office.
Yep. And so everyone, Mike just bought a new house and he is going through would you call them growing pains, Mike, of trying to get everything
Well,
together?
Put it in perspective. It was a foreclosure and, let's just say no one was living in it for 5 years. And I was shocked I didn't even know the house was there. I passed it. It was so overgrown. But now my neighbor was on his deck the other day. He was clapping when we were doing some stuff because he's just like, wow. He said we're in it now 4 weeks this Friday, and it went from being a disaster to totally livable, and we see the light at the end of the tunnel.
That's awesome. Well, congratulations. And dear listeners, we're going to have to convince Mike to have a party at his new house in Syracuse.
Not yet. It's not party ready, but we're getting there.
You're getting there. You're getting there. That's right. Well, good. All right. So if you've been following along with us, our last two episodes, we talked about what do you do when you receive a complaint from the New York State Division of Human Rights. So now what we're going to talk about is, okay, it's not the Division of Human Rights that's come knocking. It's actually the EEOC, the Equal Employment Opportunity Commission. And what do you do when you get that charge? Whether it's an email or a letter, depending on, it comes in different ways. So we're going to talk about that in this episode. But before we do that, Mike, everybody always likes to hear our wacky questions. So I'll give you this wacky question. If you could have one extra hour in every day, all right? So each day you have an extra hour. What would you do in that hour?
That's a great question. I might simply say nothing and relax.
Yep.
I will take an extra hour of relaxation every day if I could, because let's face it, everyone that's listening knows this. Somewhere along the line, everything became instantaneous, and so I'll take an extra hour of relaxation every day.
That's a great answer. So, I was going to say, go to the gym, because I used to, was a lot more active and I haven't been. But since you said that, Mike, I'm going to change my answer and I'm going to say, read. I have always loved reading, and I just, to your point, don't have the time. Everything is instantaneous and go to be able to sit and know that I'm not going to get calls or emails or anything. And I could sit and actually read a book, or a magazine. And I'm not talking, I'm not on a Kindle. I'm the old school. I want to hold the book. I want to hold the magazine. So I'm going to go with reading, that I would read. So, great. So we encourage you all to think about that too, as you listen to these. So what would you do if you had an extra hour? I'm sure number one at the top of their list, Mike's going to be to listen to us. But anyway,
I'm pretty sure that's not it. But go ahead. We'll go with it.
You're right. All right. So, all right, Mike, let's jump in. So, the Equal Employment Opportunity Commission. All right. So, you get, I'm going to say an email, because recently that's mostly what my clients have been getting. They've been getting an email, generally to HR. Sometimes it's been the CEO, and it's a letter. And it's interesting, Mike. It's an email. It's not, and so it's not a letter attached, but it looks like a letter in the email. It's the letter that you and I are used to seeing, which is a charge has been filed, and it lists, the name of they refer to it, the charging party. The division calls it the individual a complainant. The EEOC calls them a charging party. And so it'll say charging party has filed a charge with the EEOC, and it will give you information, a login to the EEOC portal, right? And so they'll give you a temporary password, and you log on to the portal, and you will see it will have information about the charge and what the EEOC wants you to do. So there'll be one of two things. One will be that it talks about a position statement. You've got to file a position statement. That would be similar to what we talked about with the Division of Human Rights. Or they will ask if you want to participate in conciliation or settlement negotiations. All right. I'll stop there for a minute. Mike, what would you say? So would you agree with that? That you get that, you log in, that's what you see?
Yeah, I agree, and they're also going to be asking a lot of questions about the size, your address, your legal name. I actually like to counsel people, call me before you log in. So we can do it together, and that way you're not saying something that I don't want you to say. I also think there's a third option, Rosemary, that I've seen. It's rare, but every once in a while I get a letter from the EEOC. FYI, a charge has been filed. We don't need you to do anything. Okay. Yeah. And we're sort of like, okay, that's odd. But no matter which of these options that are out there for you, if you have employment practice liability insurance, you need to tender this to the carrier immediately. It is a claim, and it triggers the policy. So just those of you that have insurance coverage, it is very important that you do that. And I always tell people, let's evaluate the coverage to be even sometimes before, is it worth it to turn it over? So sometimes, it's $250,000 deductible. I don't think it's worth turning over to the division unless or to your carrier unless it's a serious case. That's a rarity, Rosemary, that I tell people not to tender it, but it has happened, I think, once, maybe twice over the years.
Yeah. And, and it's interesting. You're right, Mike. I'd forgotten that they will sometimes, hey, just so you know, a charge was filed. It's the notice. And then in several of those instances, Mike, you've triggered my memory. We 2 or 3 weeks later get a letter that basically get the right to sue or that it's been withdrawn. Right. And I've had clients ask me, well, hey, what happened? Well, in some instances, it may be that the EEOC has spoken to the charging party, and for whatever reason, the charging party did decide to withdraw it. All right, and so everybody knows. We've obviously we work with the EEOC on a daily basis, and while it will not. Say that so when someone initially files a charge, no, we don't have jurisdiction, or no, that is not a valid, charge that you're making. They do some vetting. So by way of example, if someone is filing a charge under the ADA, speaking of which, Mike, I'm going to interrupt myself. So sorry, listeners. If you would just, let's remind everybody what types of charges are being filed with the EEOC, because it's different than the division. We should have started out with that. So sorry about that. But let me just finish this thought. And that is that if a charging party is filing under the Americans with Disabilities Act, and they're claiming that they needed some sort of accommodation and they were not afforded that accommodation, it was denied. The division, depending on what the individual is alleging, not the division, the EEOC, they will actually talk to and interview, I'll use that word, the charging party and say, all right, so you're saying you can't do X, Y, and Z. So tell us, how do you go to the grocery store? If you go to church, how do you go to church? Right? Are you able to cook meals? They will go through a process to see, do we think this condition qualifies as a disability under the ADA? And so it is possible that in that process, the EEOC said, and again, we would never be privy to these conversations, but I suppose it is possible they have said, you know what? This is not a disability, doesn't qualify as a disability under the ADA. And so, and the charge goes away. So
Yep.
there is a process there where they're interviewing. And so that may be, I just had one last week. We had our firm retreat 2 weeks ago, and I was at the retreat. One of my clients called and said, hey, you know, the charge that came in 2 weeks ago, we just got a notice saying that it's been withdrawn. And we talked it all through, and I explained that to them. So anyway, so that's right. So that notice can happen, and you don't have to do anything other than, as Mike said, I would put your carrier on notice because it could proceed, and generally it does. But anyway, so did you want to add to that? And then Mike, let's talk.
A couple other things I think they vet, depending on the claim, is it timely?
Yeah.
I was fired 3 years ago. They're going to dismiss it. You know. The other thing that I see is I saw someone less than 40 years old file an age discrimination claim, not a retaliation, just a straight up age discrimination. Well, they don't have jurisdiction. If you're not 40 years of age or older, they kicked it.
Yeah.
And then the third thing I have seen, it was I was wrongfully this, that, and the other thing, and I think it was because of age or whatever it was. They actually went through the allegations with them and say, well, why'd you think it was age? Well, it had to be. Why'd you think this was age? Well, it had to be. They had nothing. And they actually dismissed it. And I was shocked. But sometimes the vetting process is to our advantage because, you know, they just like, hey, it's gone. And if that person says, geez, they dismissed my claim in a day, 2 days, I'm going away. And it's probably not going to get sued.
Yeah. Yeah. So, again, you know, sorry about this, listeners, but let's go back, Mike. So, the EEOC, which laws do they enforce?
So, you know, it's different. The feds in New York State don't match up. New York State is broader, and we discussed that in the New York State Division of Human Rights podcast that we did. But we have Title VII of the Civil Rights Act, the Age Discrimination and Employment Act, the Genetic Information Non-Discrimination Act, and the did I say age? Age and is one, and disability under the ADA is the other one. Those are the big ones. Under Title VII, you'll see that's where race comes in, sex comes in, you know, national origin comes in. There's retaliation claims that can be brought. When you see an ADA, you mentioned some of the things that they're going to ask. Age, they're going to make sure you're over 40, and if you bring an age claim, because otherwise, what are you doing here? That's who they have jurisdiction over. And genetics, I haven't seen one yet.
I haven't either.
It's about 15 years, 20 years old now, the Genetic Information Non-Discrimination Act. I haven't seen it. And I think the reason is there are very few employers out there that inquire about someone's genetic makeup. I've never seen an employer make such an inquiry. When they passed the law, I sort of chuckled because I said, well, this is a big nothing. But there are cases brought under it. But it's unusual that you would see it.
Yeah. And the other thing I would add is, so under the ADA, the other thing to pay attention is, so ADA, 15 employees. Got to have 15 employees or you're not covered or subject to, that's the way I should say it, subject to the Americans with Disabilities Act. And for the ADEA, it's 20 employees. All right. So I just want to make those 2 points. And
Title VII is also 15.
Oh yeah, Title 7 is also 15. So just something to keep in the back of your mind, because we do have small employers out there, 4, 5, 6. They would be subject to the New York State Division, the human rights law, but they wouldn't be subject to the federal laws. So just wanted to make that point. So those are the laws that the EEOC enforces. And, when Mike talked about the timeliness, so it is because in New York State, there is a state law that covers all of the same, age, race, religion, disability, all of that. The time for filing with the EEOC. So it's technically 180 days from the last discriminatory act. That's the wording that is used, or 300 days from the last discriminatory act. All right. So just so everybody knows. And I think that's it on the jurisdiction, right? So the laws, the number of employees, and the timeliness of the filing in that.
Yeah.
Right.
I agree.
Agreed? Okay, good. All right. So you get the information, you've put your carrier on notice, you have a position statement that's due. The EEOC, we just got one yesterday, said you have 30 days from the date of this letter, in this case it's an email, to submit that position statement. And employers, everybody always thinks, oh, that's an eternity. It is not. It is not. All right. Because as Mike and I said when we talked about the Division of Human Rights, this is going to be a heavy lift. All right. At the beginning, when you're responding to that complaint, in this case, it's a charge, we are going to do an investigation with you. I mean, it's going to be virtual. Maybe we'll come on site, but for the most part, we're going to be asking you for a lot of documents and a lot of data. And we're probably going to ask to talk to managers or potential witnesses. I mean, we're going to do all of that so that we can put in a complete position statement. And so it will be a heavy lift. So when you read that 30 days, it's not an eternity. We're going to suggest that you request an extension of 2 weeks. It's just a matter of course. And the EEOC, just like the division, will approve that extension. And trust us, you will need it. Right. So you're going to put in your notice of appearance, fill in all the information, as Mike said. You're going to request your extension, and then you're off to the races on preparing for the position statement. So, Mike, you want to talk about? We talked about it for the division, but just quickly, just to refresh everybody's memory. Is it any different? Is it any different, Mike?
I don't think it's any different.
I don't either.
And I am one that errs on the side of giving a lot of information. If there is no case here, you want to convince the EEOC that there is no case. The reason it's important is this: if the EEOC makes a finding in the favor of the employer, the EEOC has conducted an investigation. We find no reason to believe that a violation of Title VII has occurred. If the plaintiff sues the case later, I can use that little piece of paper as part of my proof that there was no discrimination. It's not conclusive, it's not binding, but I will get it admitted into evidence. And the same will go for the complainant. If they get a finding in their favor, they will try to use it at trial. So when you listen to the DHR one that we did about what to put in a position statement, it's the same thing. Do not play games with the division or with the EEOC and say, oh, yeah, there's no discrimination here. Have a nice day. Go jump in a lake. Trust me, that's going nowhere. They want the opposite. They know many of these cases, there's nothing there. Show them. Don't play games. Show them. And let's get rid of it sooner rather than later.
Precisely. That's what I always say. I always say to everybody, this is going to be a heavy lift. But then once you've done it, you've done it. Now, so you submit that. Now, in some instances, and I've spoken, Mike, to the regional director about this at the EEOC, In some instances, they will share your submission with the charging party. In other instances, they won't, but they will pull out things, they will uh, um, identify questions that they want to ask the charging party based on our submission. All right, well, what happened on this date, or what about this or that? All right, and what's interesting is where the division might have a fact finding or two party or one party conference. The EEOC is not going to bring the parties together. Right? They're just not going to. Right? So you submit a position statement. They're going to go to the charging party, ask them questions, or possibly send the submission over, and they may or may not contact you. Right? And then all of a sudden you get the dismissal and the notice of right to sue.
Yep. And I couldn't describe it better. The process is it's much cleaner, and there's less to do than the division. And unlike the division, there's no hearing. If they make a determination in favor of the complainant, all that means is the complainant gets a piece of paper called the notice of right to sue, and they can then, within 90 days, sue the case in federal court. The funny thing is, Rosemary, if the employer gets a determination in their favor, the complainant has the same right. Once that notice of right to sue letter is issued, the first bite of the apple is done, the EEOC, and now we have to deal with a potential lawsuit, which the complainant has 90 days to file from receipt of the right to sue letter. And sometimes we get into an argument over when they received it. Was it by mail? Was it by email? But generally, it's 90 days, no matter what the finding is, for the complainant to take a second bite at the apple. And if after that 90-day period they have not sued, it's game, set, and match. It's over.
Right, exactly. Which is a thing of beauty. So, so Mike, so let me ask you this. So let's say that the EEOC decides, you know what, we think there's something there. All right, we think this is a valid charge. So talk to us about the EEOC possibly suing the case, or what happens?
Yeah, I think there's three options. Number one, the EEOC says, okay, there's probable cause. They're going to try to have a settlement conference and try to settle the case. I've actually never settled one with the EEOC because I find their numbers to be a little ridiculous.
No, but they're a lot ridiculous, Mike. Yeah, ridiculous.
Yeah, it will be something that occurs. The EEOC has the first option on the case, meaning if they want to sue the employer, they can take the case and sue on behalf of the plaintiff in federal court. One of our partners recently had a trial where the EEOC did just that. Hope that doesn't happen, because if it does, the might of the United States government will be coming down on you. They will throw everything at the case in an attempt to win. The second thing that could happen is we're not interested, and they give the complainant the right to sue letter so they can sue individually or go get private counsel. And the third thing that I have seen happen, which is rare, I had one case where the Department of Justice took a look at the case and was deciding whether to sue the employer or not, and they said at the end, no. It was an ADA case, so I don't know why they got involved, but I've seen that. Mm-hmm. But typically, it's just going to be a right to sue letter issued to the complainant. We'll have a conciliation attempt, a settlement attempt, and then it's up to the complainant to do something with that right to sue letter. Very few cases the EEOC takes, but when they do, batten down the hatches, because it is World War III and then some. Right. If that occurs.
Yeah, exactly. I couldn't agree more. Yeah, they'd like nothing more than to post. Isn't it on the website where they post? Yeah, exactly. Yeah.
And we're talking within minutes of the verdict. I mean, if it goes an hour, if the EEOC gets a verdict, I'd be shocked because that's how quick they want that press release up and out. And they get it out right away. They already have it written. They're just going to fill in the number. They could lose, but they try not to pick cases where they're going to lose.
Right. Exactly. So it is, again, you got that heavy lift at the beginning, and then you've got that nail bite period where the 90 days that you're waiting to see what the charging party's going to do. But for the most part, it's, I like the way you said it, Mike. It's a cleaner process. And I think it's probably, easier. I don't like as much being in the dark, at least with the division. You're getting you might have the two-party conference, and, you're communicating with them. You don't really have that with the EEOC,
Yeah. And the other thing I would say is it's more difficult to get the EEOC's file through a Freedom of Information Law request than it is the division, because the rules are different. And if I recall correctly, you actually have to sue the case to get access to the EEOC's file. I've only had that come up a couple times, but their access rules to their file is a little different. But I try to get as much as I can, and there's a couple different ways to do it, and I do it both ways, and sometimes I get different stuff. Just so I know whatever they're going to give me, I'll take. Most of the time, it's nothing.
Yeah. Well, and you know what, Mike, you are absolutely right that you have to have sued the case, because we had one recently, and the EEOC said, you know what, we're going to let the individual decide what they want to do. But they found probable cause, and we submitted a request. We wanted the file, and the response was like, no. Hasn't been sued, you don't get it. So you're exactly right. Literally just happened in the past couple of months.
It's just different rules, but I like the EEOC process because it's just cleaner. But you don't get as much, But that's it. I mean, that's it in a nutshell. How, in my opinion, how they differ.
I agree. So, and just to kind of bring it full circle, when we talked about the Division of Human Rights and someone filing a complaint, we talked about someone dual filing with the EEOC. So they file a age discrimination because age is a protected characteristic under the human rights law. The person's 67 years old, and or over, I'll just say over the age of 40. They dual file with the EEOC under the ADEA. All right, and as we said, when that happens, you get a no probable cause with the division. The EEOC does not do an investigation. They do none of it. They say, you know what? We're going to defer to the state agency. Let them do the investigation. Let them come to some determination. As we said in our episode on the Division of Human Rights, you will send a letter to the EEOC asking them to adopt the division's determination. They will adopt it, and they will issue the right to sue. So when the EEOC is involved in that, you don't have to do anything other than the letter and then wait for the 90 days to pass.
Yep.
Yeah, that's really it. So that's how the two kind of work together. So, all right. Well, with that, I think we covered it all, Mike, which is great. So before we wrap up, so I have a question, Mike. Where are you going to be on October 29th?
Probably at the Turning Stone Casino, if I'm correct.
Yeah, and what are you going to be doing at the Turning Stone Casino, Mike?
We will have our labor and employment symposium. It will be our second one that we are doing, and you will be getting basically a hold the date and then an invite rather soon. It will be a great day between all the speakers that we're going to have on lots of topics. And more information to follow on it. But if you're seeing this, it's not too far off, because you're either seeing this at the end of August or early September. So just be on the lookout. And if you don't get an invite for some reason, because those probably come in electronic, let us know. And you can just sign up, no charge. And it's a great day.
Yep. Terrific. Great. Thanks, Mike. All right, everyone. Well, once again, it was great spending this time with you. Hope you found this information helpful, that you can find us on Spotify and all those other cool podcast platforms. Feel free to leave comments, questions. Feel free to send Mike or myself questions. We've actually had several people reach out to us with questions, and a couple have asked us to do particular episodes. In fact, the episode that we did on meal periods was a request. So if there is something you want us to chat about, let us know. We're happy to do it. So have a great day. And Mike, we'll see you soon.
You got it.
The Labor and Employment Podcast is available on BarclayDamon.com, Spotify, and all major podcast platforms. Be sure to like, follow, and stay connected for future episodes.